If you are going through a divorce, or someone you care about is, there is a good chance that thousands, sometimes hundreds of thousands, of dollars are sitting in accounts that one spouse doesn't know they're entitled to. Not because anyone is hiding them, because nobody explained the rules. Divorce is one of the most legally complex financial events a person can go through, and most people navigate it without understanding what they're actually owed. This video is going to change that. We're covering the 6 financial rights that get overlooked most in divorce, including one that disappears entirely if you don't act on it before the paperwork is final. Quick note before we start. Divorce law varies significantly by state, and this is educational information, not legal advice. If you're going through a divorce, please work with a family law attorney, especially for anything involving retirement accounts. Subscribe. This is exactly what this channel exists for. Let's start with the one that surprises people most. Your spouse's retirement accounts are very likely marital property, even if your name is not on them. In most states, retirement plan contributions made during the marriage are considered marital assets, regardless of whose name is on the account, and regardless of who made the contributions. That means if your spouse spent 20 years building a 401k while you raised children, managed the household, or earned less, you may be legally entitled to a share of that account. The same is true for pensions, profit-sharing plans, and most employer-sponsored retirement plans. The tool that makes this possible is called a Qualified Domestic Relations Order, a QDRO. A QDRO is a separate court order, beyond the divorce decree itself, that instructs the retirement plan administrator to pay a portion of the account directly to the non-employee spouse. Here is the critical thing most people don't know. A divorce decree alone is not enough. Even if your settlement agreement says you are entitled to half of the 401k, if there is no QDRO filed with the plan, you may never see that money. The plan administrator is not legally required to honor your divorce decree without a QDRO. And if your ex-spouse retires or dies before the QDRO is filed, you could lose your rights entirely. Get the QDRO done before the divorce is finalized, or as close to it as possible. This single step is one of the most commonly skipped and most financially damaging oversights in the entire divorce process. Second, if you were married for at least 10 years, you may be entitled to Social Security benefits based on your ex-spouse's earnings record. This is a federal right that has nothing to do with state divorce law. If your ex-spouse's Social Security benefit is higher than yours, and you were married at least 10 years, are currently unmarried, and are at least 62 years old, you can claim up to 50% of their benefit. This does not reduce your ex-spouse's benefit by a single dollar, and they never have to know you claimed it. Millions of divorced people, particularly those who left the workforce or worked part-time during the marriage, are entitled to this benefit and never claim it. If you remarried, you generally lose this right, unless that subsequent marriage also ends. Third, your share of marital property includes more than the obvious assets. Most people think about the house and the bank accounts, but marital property in most states also includes stock options and restricted stock units that vested during the marriage, business interests built during the marriage, deferred compensation, professional licenses and degrees in some states, and any appreciation in value on assets that occurred during the marriage. It also includes debt, mortgages, credit cards, car loans, and any other liabilities incurred during the marriage are typically marital debt regardless of whose name is on the account. This matters because taking the house while your spouse takes the 401k might look equal on paper, but $1 of home equity is not the same as $1 in a tax-deferred retirement account. One has liquidity and future tax consequences. The other has neither. Work through the after-tax value of each asset before you agree to any division. Fourth, if you were financially dependent on your spouse, alimony, also called spousal support or maintenance, may be available to you. Courts consider a range of factors: the length of the marriage, the income difference between spouses, the standard of living established during the marriage, the career sacrifices one spouse made to support the other, and the age and health of both parties. Alimony is not automatic and it's not guaranteed, but in a long marriage with a significant income disparity, it is often available and regularly underutilized. Even temporary alimony during the divorce process, called pendente late support, can be requested while the case is ongoing. If you are the lower-earning spouse, do not assume you aren't entitled to support without at least having the conversation with an attorney. Fifth, watch your credit during the divorce process. Joint accounts, joint mortgages, and joint credit cards remain joint liability until they are legally separated, and a divorce decree does not change that in the eyes of creditors. If your name is on a mortgage and your spouse is ordered to pay it but doesn't, the lender can still come after you. Close or freeze joint accounts as soon as the separation begins. Open individual accounts in your name only. Monitor your credit report for any accounts you may not know about. And get any property transfers done properly. A verbal agreement that your spouse will handle the mortgage means nothing to the bank. Sixth, document everything before you file, and ideally before your spouse knows you're planning to file. Once divorce proceedings begin, financial records can become harder to access. Before anything is filed, gather recent tax returns for both of you, bank and investment account statements, retirement account statements, mortgage documents, business records if your spouse owns a business, and any records of major assets or transfers in the past few years. Courts can set aside fraudulent transfers, assets moved to hide them from the divorce, but only if you can show they happened. Having documentation from before the process starts gives your attorney the full picture and makes it significantly harder for assets to disappear. Here is the summary. Retirement accounts earned during the marriage are likely marital property. Get a QDRO and get it before the divorce is final. If you were married over 10 years, investigate your Social Security spousal benefit rights immediately. Marital property is broader than most people realize. Includes stock options, business interests, debt, and after-tax values in every comparison. Alimony may be available even if you assume it isn't. Ask. Protect your credit from the moment separation begins. And document your financial picture before anything is filed. Divorce is one of the most consequential financial events of a person's life. The people who come out of it in the best position are not necessarily the ones with the best attorneys. They are the ones who knew what they were entitled to before they walked into the room. Subscribe. We cover tax and legal situations like this every week. Share this with someone who needs it.